The Federal and Pedesta Hospital jointly present the Kanyakumari Marathon 2025. This event is co-presented by Rojavanam International School and Kingmakers IAS Academy. Run for Health on Sunday, May 4, 2025. Entry is free and all are welcome.
Of threat in fear of injury had committed suicide also. So look
Oh,
at that.
it's quite shocking. The witnesses, they were in fear, and some of them even forced to commit suicide.
The way the police had actually handled, Murugesan's mother, the way she was brutally abused, the way she was used with foul languages and filthy words was really unacceptable.
In every case, you will see accused would try to delay the matter.
Hello, federal viewers. Welcome to a special interview with Supreme Court advocates Rahul, Shyam, Bhandari, and Ms. Priyadarshini. Both of them argued in a very sensitive honor-killing case in Tamil Nadu. It's known as Kannagi-Murugesan case. After 23 years of the battle in various courts, from trial courts to Madras High Court to now with the Supreme Court, the case in which young couple named the woman named Kannagi and the man named Murugesan, both of them were killed by the woman's relatives because they fell in love, and the marriage turned out to be an inter-caste marriage. The couple was forcibly fed poison in the full public view, and both of them were brutally killed and cremated in the village burial ground way back in 2003. Supreme Court awarded life term to 10 persons involved in this case, which includes the brother of the woman. And this case also convicted two police personnel for not investigating the case properly. So now let's hear from advocates Rahul and Priya about the journey that got justice for Kannagi and Murugesan. First, I would like to understand what were the legal challenges in securing convictions in this case, because there's a long gap, right? 23 years. It's not short time. And what were the great challenges in securing convictions?
This occurred in 2003. Ultimately, when a local police had investigated the case, that investigation was a bust-up investigation leading to appointment of CBI in year 2005. So insofar as the investigation part is concerned, that was covered within a period of 2 years because CBI filed a report in 2005. Thereafter, case is supposed to go to the trial court for committal of the case, we call it, that the case will be assigned to the judge. And then the trial starts. Unfortunately, in this case, the committal happened only in year 2010, which ideally should have happened immediately, or say, within the period of 6 months.
Yes.
And therefore, after 2010 to 2017, the trial could not proceed at all. And this part has been, dealt by the trial court in detail and by the High Court. This delay occurred because the hostility of the case was too much. One side there were Banyas and the other side were Dalits. And it has been duly recorded with the trial court and the High Court. Many of the witnesses were not ready to come forward. And many of the Dalit witnesses, in fear of threat, in fear of injury, had committed suicide also. So
Oh,
look at that.
it's quite shocking. The witnesses, they were in fear, and some of them even forced to commit suicide. Okay.
Exactly. So that was the level of atrocity, and the trial court deals with it. The High Court deals with it beautifully. Says that, look, this offense, and this could not be tried for many years because there were a lot of interference. Otherwise also applications were filed. They kept on filing applications. They kept on delaying. So I believe we can tell it's a part of the system. The system is also responsible for this delay.
Now I want to hear from Priya. So can you explain to me what motivated you to take up this case? Did this case impact you professionally or personally?
Personally, for yes, sure, because this has been a very big challenge for both of us. It was more emotional for us to get connected. In fact, Rahul, I remember him sleeping only for like 3-4 hours a day. Because we are lawyers as well as we are scouts, so like the litigation continues at home, the discussion continues there as well. So this did impact, it did have a lot of impact because the facts of the case was very, very trembling. When you just get to read the file, when you get to read the love letters, one side, the amount of love, the passionately Murugesan and Kannagi had for both of, for each other. And on the other side, they also had a fear, and they also always had this fear of being this is going to be a big challenge. Sometimes Murugesan loses hope and Kannagi gives him some confidence. Sometimes Kannagi loses hope, Murugesan gives confidence. All of this in the letters, and the way this entire execution had happened, the way they had brutally handled Murugesan was like it was no less than a movie script. And the way that the entire police had taken a twist and turn, trying giving a new thesis and a new theory, and trying to kind of target the lower community, the SC community, which the Supreme Court itself, the judgment has mentioned.
Yes, I want to intervene in this part. I learned from this case that two police officers who did not investigate this case properly were also convicted. Is that so? How can you explain that bit?
Yeah, that is true. So what had happened, as I told you initially, when the media pressure came up and this incident was blown up, and then the local police started investigating. So therefore, there was one IO and there was sub inspector. So they both had investigated the case. Who were ultimately accused number 14 and 15. So they filed a report saying that on the one hand there were four Dalits who were also responsible for this incident, and then four Vanyas. So ultimately, when CBI kicked in, CBI came up with a report. No, nothing. This report is false, and in fact, it is the local police officer who has misled the investigation, who has attempted to implicate the Dalits. That's how even the trial court and high court records, and then Supreme Court has finally held in the judgment that out of two police officers, one was given 3 years, and the main officer who investigated the case and who had implicated entire thing, who had framed Dalits, he has been given life.
How significant was this judgment in terms of president for the future honor killing cases?
Why this judgment is very significant? Because ultimately you are dealing with the rarest of rare crime. Honor killing is considered the most ghastly crime, the rarest of rare crime. Earlier also Supreme Court has given judgments when it comes to crime like honor killing, we must be dealing it very seriously, and there should be a very you should deal with iron hand. You should not give much of flexibility. Now, when this case came up before Supreme Court, obviously so many accused were involved, complicated facts, change of investigation, trial court detailed judgment. So Supreme Court was expected to deal with each and everything. Now this judgment is going to be cited as a precedent in cases of honor killing. How to deal with these cases, and more so, this judgment also deals with many of legal propositions. Calling for additional witness turning hostile, change of investigation. When you say that, look, this witness is a related witness, he's my father, his brother, he cannot be cited as an independent witness. So overall, legally also, it is going to be a very landmark decision.
Okay, so in this case, what kind of support system in any honor killing cases? What kind of support system is lacking for the victim?
Absolutely, the police. I think it begins with them. So when there is a honor killing or anything which is against the state, the first person who has to take the responsibility and act sensibly is the police. And when the police, unfortunately, see, this is not a statement of the police system per se, because we know they are wonderful police officers as well, who are running the show very seamlessly. But very unfortunately, handful of these kind of police officers actually taints the image. What happens is this reduces the confidence of the victim to come over to the police station to give a complaint first and foremost. And secondly, how do they actually treat the victims is also another challenge, particularly when it comes to this case. The way the police had actually handled, Murugesan's mother, the way she was brutally abused, the way she was used with foul languages and filthy words was really unacceptable. One side, she's actually seeing her son being stripped, being tortured. He was being typically tied, over to a tree.
The pole.
Yeah, and then he's like undressed, and like they're ripping his skin off, and he's still not telling where Kannagi is. So he's like topsy turvy. He's dipped into a bore well hole, which is 300 feet low. And like in such a speed that he has to say, and there's nothing much a person can do. So that's when, after a tedious torture, he'd actually come up to saying where Kannagi was. And in such a scenario, the mother runs to the police station twice in separate intervals, along with the sister, Murugesan's sister and aunt. And both the times she was typically chased and abused. So who has to be protected here?
They refuse to register the FIR on the ground that you belong to Dalit caste. And this is not what we are saying. This is based on the evidence that trial court and high court has recorded. So naturally, the first person you will approach is the local police. And if they fail to act, then this is a complete failure on a part of this system.
So, can you please explain to us about, how the procedural delays or hurdles would complicate in these kind of cases?
Yeah. So therefore, as I indicated in the beginning of this conversation, that look, ultimately when you're suppose when you're involved in such a case, and when as a complainant, this is you have approached court, the first endeavor is first expectation is justice at the earliest. So what happens that we must find out in an objective assessment where and how to conclude the trial and within a limited span of time. In every case, you will see accused would try to delay the matter, right? Sometimes even complainant will not be very active. So, like in this case, what happened that for 5 years, it took 5 years from 2005 to 2010 to the committal of the case. Thereafter, 7 years for the trial court to begin with the trial. Why? Because the accused kept on delaying the matter. High Court has lamented on this thing. High Court has come down heavily on all those things. But look, these observations can only serve as a precedent, but which we must come out with, as my friend said, that look, we could have a system where we can fast track this kind of heinous offenses. We have such structure for other offenses. We can do with such,
So that kind of legal framework will help in getting judgments in a much shorter time.
Yeah, because the victims and also the witnesses, one, there's a scope of getting tampered, which actually we see in this. And secondly, we've also told you examples of them committing suicide with the pressure that they have been given. And thirdly, you forget the facts of it. It's not very natural for somebody to remember the facts for like decades together.
Fine. Thank you, Rahul and Priya, for this conversation. Thanks much, and best wishes for your work. Thank you.
Thank you so much, Pramila. We only wish that may not there be another example like Kannagi-Murugesan that any of us in India have to face in the future. Let's all be responsible and let's have a little more empathy towards each other as a nation is what we request. And thank you so much.
I'm sure this judgment will send a deterrent message across the society as against such offenses.